Hello everyone, we are back here on the channel with our U.S. Constitution Explained series, and today we are looking at the Fourth Amendment to the U.S. Constitution. This one deals with searches and seizures, and much like our video on the First Amendment and the Second Amendment, there are different modern interpretations of the application of this amendment today in the 21st century because, of course, when they wrote the Fourth Amendment, there was no internet, there was no modern policing. And so we're not going to get into the different arguments of the extent of the Fourth Amendment today. We are just going to look at the historical rationale for writing the Fourth Amendment. What led the Founding Fathers to write this as it reads in the U.S. Constitution? So we should start just with reading the document itself. So, the Fourth Amendment to the U.S. Constitution reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So again, the rationale for writing this would have nothing to do with what we see today as modern police forces, because of the fact that they didn't have modern police forces back in the 1700s. In fact, they didn't really have organized police forces at all. They had night watches that the citizenry were responsible for keeping order. They had sheriffs and loose constables around the country, but that was about it. Now, it is true that the Fourth Amendment today does limit the power of the police to seize and search people, to search their property, to search their homes. You've probably heard of search warrants. That's where this comes in. But again, what led the Founding Fathers to write this document? Well, it has to do with their history as citizens of the British Empire. So they were concerned with both general warrants and writs of assistance. General warrants based on what they had seen happening over in Great Britain, and writs of assistance based upon what they saw in the lead up to the American Revolution. Writs of assistance is something that I have covered here on the channel in one of my videos about the causes of the American Revolution. So over in Great Britain, general warrants were often used by the crown as a tool to go after political enemies. These general warrants were issued and allowed them to search without any cause if they believed someone had committed an offense against the crown. Because of some court cases over in England, it was ruled that these general search warrants did in fact violate English common law. Here in the colonies, writs of assistance, this was like again, kind of a general search warrant that allowed government inspectors at this point, because the United States was part of the British Empire, those government inspectors working for Great Britain to look for evidence of smuggling, of merchants not paying their taxes or importing goods that they were not allowed to have. And these general search warrants here in the colonies, called writs of assistance, often led to harassment of merchants because there was no time constraints on how long they had the ability to use the writ. So they could go in and they could look pretty much whenever they wanted for evidence of smuggling. This led to one of the Founding Fathers, James Otis, often calling on this old British quote from the early 1600s where it was declared that a man's home is his castle, meaning that a man's home could not be invaded by the government. So again, this amendment is about having to require a search warrant for searches and seizures. These search warrants have to be obtained by a judge in advance. If that does not happen, it is understood that any evidence brought forth in a trial that was not obtained via a search warrant is tossed out of the trial, even if sometimes it shows that a person is guilty. This is called the exclusionary rule. So in order to get that search warrant, probable cause should be shown. And essentially what you want to have here is all searches and seizures cleared ahead of time by a judge. Now, in practice, it's just not really possible. In modern policing, warrants are oftentimes not obtained because there are so many exceptions. Police can search automobiles without a warrant. They can detain people on the streets, and they can search and seize under the cause of it being an emergency. And so again, this is why there are lots of arguments today about the Fourth Amendment in practice, but the historical rationale for it relies upon this idea that there were the general warrant problems over in Great Britain, and there were the writs of assistance problems here in the American colonies. So here with the founding of the United States, they wanted to make sure that searches and seizures could not happen without a warrant gained in advance from a judge if probable cause was shown. Modern policing did not exist at the time that the Fourth Amendment was passed. And of course, what about the government using drones? What about the government wiretapping? All of these issues are for judges to decide today. So with things like drones, the internet, the Fourth Amendment is going to come up again and again because the world we live in today is so much different. We want to remain safe, but we also want to have protection against the government going too far if they do not have probable cause. And so the Fourth Amendment you will hear about for the rest of your life, no question about it. But that is the historical rationale for the Fourth Amendment. Hopefully this came in handy for you. If it did, hit that like button, subscribe to the channel. I would greatly appreciate it. And we'll see you here next time on Mr. Droste History.